Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and I'm coming to you today from the state of Washington, near Seattle. I'm here for a Trial Lawyers College workshop and retreat where the attorneys work together in a continuing legal education to improve your skills, to get better, so you could do a better job for your clients at trial. And it's, been one day so far, and I thought it was really helpful and amazing and learning a lot and meeting a lot of great people. And actually, one of the other participants just got a verdict in another state. It was in the state of Georgia, near Atlanta. He just got a verdict he actually tried the case with his wife, as well as a co-counsel. So the three of them partnered up and they tried this case and they got an amazing verdict, $5.25 million. And it was actually a soft tissue type of case, meaning there were no injections and there was no surgery. So find out how they did it. Let's get into it. I'm going to do a quick video where we get into some of the details and we comment about some of what they did, how they did it, and the story about this case. And before I get into it, I just want to say that this particular attorney was also at the same Santa Barbara trial by human workshop that I did in California a few weeks ago. I believe that was at the end of March, and I shot some videos from there. And he was there, and he's actually the only attorney that was there as well as here at this conference. Me and him are the only two that did both. So I thought it was really, really funny. So he actually, at that trial by human Santa Barbara, California conference, he actually workshopped this case. So he actually practiced, this case in front of other lawyers and in front of the instructors and the people that were running the workshop. And now, it was successful, right? The workshop worked. He got 5.25 million. So anyway, let's get into the case. So basically, it was actually a slip and fall case, which that's some of the most difficult cases. And the verdict just came down last week, Friday, at 4:30 p.m. And this was in Atlanta. And so the case, involved a slip and fall. It was a lady, and the lady had a past medical history battling cancer. She was actually battling cancer for the past 17 years. And then her cancer had been in remission since 2018, but it came back in 2022. And her doctor said, look, we exhausted all of the treatment options, and they even had to remove one of her lungs. And they said basically that that's it. You're going to die. There's nothing else we can do for you. But 3 weeks before the trial, she went to a cancer treatment center in Atlanta, and she was actually told, now there's no evidence of cancer. The cancer's gone. So, and we're going to come back to that. I'll explain to you how that was relevant in the trial. But how it happened was she was in a store, a clothing store, and she had gone up to try some clothes on to the dressing room. And so the associate who's in charge of the dressing rooms told her, go ahead, just go on into the dressing room. And she goes in there, and right before she enters the dressing room, she has a slip and fall because there's a wax buildup. There's wax on the floor right before the dressing room. And so the plaintiffs were able to show that the wax had been there for at least 7 or 8 hours. And the wax was there because they had a problem with their cleaning crews. And so, so she has this slip and fall, and she has a serious back injury. And so the defendants, it was this dressing store. It's actually called Dress for Less. And so this store, this corporation, they have many of these stores, Dress for Less stores all over. And so they had 3 defenses. Number one, they said, we actually warned this lady right before she was about to go into the dressing room. We told her, hey, watch out. There's a slippery condition there. There's wax. So number one is the defendants are saying, hey, we warned her. Number two, they said there was a wet floor sign, one of those yellow caution signs, and she ignored it. And number three, just for good measure, they said, it's not even a big fall. It was just a little fall. She slipped, she got right back up. It was nothing. So that was the defense. And so when the plaintiff's attorneys took the deposition of this particular employee who was saying all these defenses, right, these three things, they found out that right before the deposition, this employee got a promotion. So that was interesting. And then, what the defendants ended up doing was they got rid of basically all the evidence. They were supposed to do certain things according to their own policies and procedures, and they didn't do it. They got rid of a lot of evidence, and all they had was one incident report, one piece of paper, and it was from a third-party administrator known as Sedgwick. You might have heard of Sedgwick. They handle a lot of big, multi-million-dollar claims. So anyway, there was this one incident report, and the incident report said that there was a single witness who was the same employee who got the promotion, who was saying all these things, right? So then the way they handled the trial was, in jury selection, they tried to build a tribe or form a group, right? Because you have all these different jurors. And, they're not jurors yet, they're panelists. They're people sitting at home, opening their mailbox, getting this notice saying, hey, come to court, and, you have to do jury duty. And people are like, oh, no, I don't want to do jury duty. And then all of a sudden they show up. Now all these people are sitting there in the courthouse, in the courtroom, maybe 30, maybe 50 people. And the plaintiff's attorney gets a chance to chat with them and see who would be good for the case. So what they wanted to do is they wanted to form a group, get these people connected to each other, get them connected to the plaintiff's attorneys, and they build the connection around the issues of safety and the issue of integrity or truth. And so they formed that group. And then once they had their jury, they started the case. And the first thing they did was one of the attorneys on the team, there were three attorneys. There was this attorney who went to the workshop, there was his partner, and there was also his wife who's an attorney, and the three of them. So his wife actually started the case, and she started the case by doing a direct examination of this employee who's known as a manager on duty. And it turned out for the plaintiff, it turned out that this particular employee, by the time trial came, he was no longer a direct employee of the Dress for Less store, but rather he had left or was fired, and he was an ex-employee. And this is a really good strategy, by the way. If you can find an ex-employee in any case, they often tell you the truth as opposed to, towing the company line. Because when they're working there, they're afraid that they're going to get fired, they're going to get demoted, or there's going to be some kind of punishment. So they kind of say what their boss, the corporation, expects them to say. But when they're an ex-employee, they no longer work there, and there's no longer this burden over them to say what the company needs or wants them or forces them to say. But they could say the truth. They could say what really happened. So what she did with this on direct examination, she called him, this ex-employee, and she showed that past customers who went into the same dressing room also fell and were injured by the same wax buildup in the same spot, that this was like a problem that would happen because of the way, it doesn't say from the write-up that they did, what exactly the problem was. I'll find out, actually. I'll see the attorney today, so I'm going to ask him. But I don't know exactly what the problem was, but according to the write-up, it says the problem is with the way that the cleaning crews were working. So probably like the waxing machine would leave some wax on the floor, maybe some kind of problem with the way they were doing the waxing or the machine, but it was a problem with the cleaning crew. And so she was able to show that past customers were also injured, and she was also able to show that this wax was there for at least 7 or 8 hours. So they either knew about it or they should have found it and fixed it. And that is also the standard with notice. You either have to have an actual notice that you actually tell somebody about it, and then you actually know about it, you should fix it, or that if it exists for a long period of time, and here it's a really long period of time. Some courts have even said just that if a defective, unsafe condition exists for 15 to 20 minutes, that's sufficient. And here it's existing for 7 or 8 hours. So the next thing they did was they did the direct examination of the plaintiff. And what they wanted to show is that she had a vision of hope despite all these problems. Like we said, she was battling cancer since 2018. And, the cancer went into remission in 2018, but she had been battling cancer for 17 years. And this particular slip and fall actually happened in 2017. So in 2018, the cancer goes into remission, but then it comes back with a vengeance in 2022. And this trial just happened now in 2024. And right before the trial, this particular plaintiff was told, hey, this cancer is gone. So she thinks, maybe like 2-3 months before the trial, she thinks that she's going to die, right? Because the doctors are saying, there's nothing we can do. We've exhausted all options. We've already had to do a surgery to remove one of your lungs. This is it. There's nothing else we can do. This is an end-of-life scenario. And then all of a sudden, she just goes for a checkup and she's told, we don't even see the cancer anymore. So she's so overjoyed that what she does is she goes to her church and, she celebrates. And so the defense lawyer on cross-examination, what he ended up saying was that he basically said, look at this social media video. He finds it like on Facebook, and she's dancing with pure joy with her congregation in church. And the defense lawyer tries to suggest that, look, you don't have any apparent limitations. You're not really hurt. And so the plaintiff thought that that was actually a gift, because he said this was just jaw-dropping and completely tone deaf, because this lady had just found out that her cancer is gone, that she's going to be able to live. And before this, medical science had told her there were no options and you have to be ready to end your life. And now it's almost like a miracle happened, and she's rejoicing with her spiritual community, with her friends from church, and they're trying to use that against her to say that you're going to be that you don't have any limitations. And so her main injury was actually that she needed a 3-level fusion, and she could not have had the 3-level fusion, I guess because of herniated discs. She could not have had the 3-level fusion because she only had one lung, and so with one lung it's very dangerous to do that. So so basically, like the story that they told during trial was that this corporation betrayed this lady and mistreated her for many years. And then the lawyers also did a cross-examination of a corporate representative. And a corporate representative is somebody that the corporation chooses, and then they could prepare that person, and that person becomes the voice of the corporation. There's a federal law called 30b-6, and in state court, you could also have corollaries, and in Georgia they have one. So what the plaintiff's attorney does is it says, okay, give me a witness who's going to be the voice of your company as to these issues, and you list the topics, like, for example, safety, cleaning crews, wax buildup, inspections, or whatever the plaintiff's attorney wanted to put in the notice. And then the defendants produced someone. So here they produced a corporate representative, and the corporate representative also had to bring all of their manuals, their policies, their procedures, and their own website, their own manual said, look, for us, the Dress for Less store, safety is our #1 priority. So when the plaintiff's attorney cross-examined this witness, he said, look, you're the voice of the company. You are the company. What you speak is what the company stands for. And this is big corporate outfit, Dress for Less. And he said, so you're saying safety is your #1 priority, but you violated your own policies. Your policies say that you have to keep witness statements. You have no witness statements. Your policies say that you have to have an internal incident report. You have no internal incident report. And your policy says you have to have photos. You have no photos. All you have is this one page from a third-party administrator that's being hired by an insurance company, right? And the insurance company wants to defend the case, wants to settle it for nothing or as little as possible. And that's all you have is this third-party administrator, Sedgwick's one-page report. Where are the witness statements? Where are the photos? Where's your internal incident report that the store made? You don't have any of that. And so the defendant's story also changed, and on cross-examination, he showed it because originally they said there was this one male associate, and he let her into the dressing room, and he actually warned her, hey, there was wax there. But right before trial, the corporation changed everything, and now they said there was a female associate who let her in. So they exposed all these contradictions. And then finally they did a closing argument, and in the closing argument, they showed how the defendant engaged in delay, engaged in destroying evidence, failing to produce evidence, and also witness manipulation. And the plaintiffs argued that this was all a tactic throughout the litigation. Because remember, this happened in 2017, and it went to trial in 2024. So that's 7 years later. And throughout this entire 7 years, the insurance company was offering zero, or at one point they were offering $35,000. That's it. So the plaintiffs said, look, what they really hoped for was to outlast this lady because they knew she had cancer. They knew, because they have authorizations, right? They can get her medical records. They knew that she was being told this is an end-of-life scenario. So they hoped to just wait it out, let her die, and then it's worth nothing, as opposed to paying a fair value, real compensation for what this is worth. So right before the judge was going to read the jury instructions to the jury, that's when the trial ends and the jury goes into the deliberation room and thinks about a verdict. Right before that, they finally upped their offer and they said, look, $35,000, okay, we understand. So how about $275,000? We're going to give you that, but it's going to be off the table as soon as the judge finishes reading his jury instructions. And so the plaintiff's attorney politely declined that. And so the way it works in Georgia is that the plaintiff's attorney gives a closing argument, then the defendant gives a closing argument, and then the plaintiff's attorney has a short rebuttal. So the plaintiff gets two closings. And the way they did it was one of the attorneys gave the first close, and then the defendant went, and then another attorney, actually the attorney who was with me in Santa Barbara and is here at this conference, he's the one who gave the second closing. And in the second closing, what he did was he polarized the case. And he said, look, you can choose either to accept Ross's version of events, right? What they're saying, that first there was this male employee, and then there was a female employee, and that they warned her, they told her, hey, you have wax right here, and then she just went in and slipped on the very wax they warned her of, that they had these yellow caution signs that said wet floor, and that she just ignored it. So, and now she's bringing this lawsuit. So if you believe the defendants, that just means that my client, this lady, is a liar, a cheater, and a fraud. So you can believe that. That's one of your options. Or you could believe that this company is trying to cover up and hide the truth and hurt this innocent victim. And it's like he gave them two different options. And that's known as polarizing the case, right? Polarizing. It's polar opposites. And he also tried to waive the medical bills because her medical bills in this case were only $25,000. So he said, look, I want to waive the medical bills. But the judge was actually a little bit more conservative, and the judge said, no, you can't waive them. They're coming in. And so the defense harped on the fact that there were only $25,000 in medical bills, and a lot of lawyers, they think, oh, okay, the verdict should be a multiple of the medical bills. So if the medical bills are $25K, the verdict should be maybe $75K, like 3 times medical bills or whatever, some kind of numerical factor. But the plaintiff said, look, if you think that these $25,000 in medical bills are any predictor of how the pain impacted and will impact this nice lady for the rest of her life, then, that's just not true, because she does need this 3-level fusion. The only reason she's not doing it is because she only has one lung and she medically can't do it. So anyway, so then the jury came back, and the jury rendered a verdict of $5,250,000, and they gave 10% apportionment to the plaintiff, because the actual theory of why they thought the plaintiff was 10% at fault was because the plaintiff knew that she was doing chemotherapy and she only had one lung. So they thought, well, but if you're going to like public places and you're trying to walk with these medical conditions, you may be a little bit at fault because you know your own health condition. So that's the only reason they gave her 10%, but otherwise they found the store 90% at fault, and they gave this verdict. And the other good thing about the verdict is that the plaintiff also gets attorney's fees. There's prejudgment interest. So with the prejudgment interest, there's going to be a separate post-trial hearing for attorney's fees, because before, in like the summer of 2022, there was actually a much lower settlement offer that the defendants could have taken. I think it was a few $100,000. And the defendants, said no to that. So because of that, under the state law, they can now get attorney's fees for that, a post-trial hearing for attorney's fees, in addition to this verdict. So they felt like this was really a satisfying victory for an amazing human being, and they were just grateful for the community. They were grateful for the jurors. Actually, I believe after the trial, the jurors even wanted to speak to the plaintiff, speak to the plaintiff's attorney, and one of the jurors even said, hey, when are we going to all take a picture together? So you could see, if the jurors are saying that after a trial, when are we all going to take a picture together, you know that they built a tribe, built a strong group, had a nice community, and so it was a real verdict for justice and for the truth. So I hope this was helpful. Let us know what questions you have. We are here for you. If you have any questions, please like and subscribe to our channel. You could text me. My number is 347-566-9595. And like I said, we are here for you. Our goal is helping serious injury victims and families. And all the best, everyone. Okay, bye-bye.